Hello, everyone. Thanks again for tuning in to our continuing series of webcasts on the new lay of the land as it pertains to COVID-19 and immigration. One of Donald Trump's last attacks on U.S. immigration process before COVID hit the world was to mandate all incoming immigrants prove a negative by demonstrating that they will not become a public charge before getting a green card or an immigrant visa. The public charge mandate went into effect on February 24th, just weeks before shelter-in-place orders were issued and the nation effectively shut down. Even in the old world order, the public charge rules were unfair and discriminatory. Today, we'll discuss the rules as America emerges from the shelter-in-place rules and slowly reopens for business in the midst of the COVID national emergency. I'm thrilled to have with me as our special guest, Paul O'Dwyer, discussing this issue. Paul is a renowned immigration attorney practicing in New York City. His website with all his contact information is www.paulodwyerlaw.com. Paul, thanks again for returning to our webcast. Welcome.
You're welcome. Thank you. It's nice to see you.
Yes. So let's dive right into this, Paul. What does public charge and public charge rule mean within the immigration context?
So the Immigration Act has a provision in it that says that people who are likely to become a public charge at any point in the future are inadmissible to the US. And that has always been there. That's been a permanent feature of US immigration law as long as there's been US immigration law. And it applies to people who are applying for green cards or for permanent residence. And just for people who are listening, so we use the term application for green card, application for permanent residence, adjustment of status. We use those terms interchangeably. They all mean the same thing. And it applies to people who are applying for green cards based on sponsorship by family members and who are applying for green cards based on sponsorship by employment. So really it's sponsorship-based immigration. It doesn't apply to people who are getting their green cards or adjusting status through having had asylum or through having had a U visa or people who have been granted benefits under the Violence Against Women's Act. It's purely based on family and employment sponsorship, and that's who it applies to. And there's a related concept, and people sometimes think that they are one and the same thing, and they're not, but there's an affidavit of support requirement. And the Immigration Act also requires that people who are subject to the public charge ground of inadmissibility based on family sponsorship, not employment sponsorship, based on family sponsorship, must have an affidavit of support. And that's a form that is signed by the sponsoring relative, whether it's a spouse, parent, child, saying that they will be financially responsible to the government for any means-tested benefits that the person who is being sponsored incurs for a period of 10 years after they become a permanent resident. And in order to file that affidavit of support, the person has to show that they have an income of 125% of the federal poverty guidelines for that year.
Okay, so just a couple of clarifications. The public charge rule, it does apply to people applying for immigrant visas overseas, correct?
Yes, it applies to people who are applying through a US consulate overseas for a permanent resident or for an immigrant visa, and also people who are applying for adjustment of status in the US.
Okay. So if we've had this affidavit of support that's been in existence since I was a child, and now why is public charge rule different than what we had already under affidavit of support? Because affidavit of support did cover that whole issue. If somebody if somebody got a green card and came here and started using means-tested benefits, the petitioner was still liable. So what's different now?
So what's different now is the petitioner still remains liable, but what is different is how immigration officers determine whether or not somebody is likely to be a public charge. And before the affidavit of support, if you were applying for permanent residence or applying for an immigrant visa through a consulate overseas, you would have an affidavit of support. And that was typically enough to satisfy the public charge ground of inadmissibility, or to show that you were not likely to become a public charge, unless there was something very glaring from the application that said that you were likely to become a public charge. But for the vast majority of cases, the affidavit of support was enough to satisfy the public charge inquiry. Now that has changed, and under the new rule, first of all, we have a definition of public charge, which we didn't have before. And the definition of public charge is a person who has received more than 12 months of specified means tested government benefits out of a period of 36 months. And in order to apply the public charge ground of inadmissibility to intending immigrants, it requires the immigration officer to do a totality of the circumstances evaluation based on a number of factors, some of which are considered to be heavily weighted negative factors, and some of which are considered to be heavily weighted positive factors. I should also point out that for the first time, also, this receipt of benefits is also being applied to people who are non-immigrants. So people who are applying for temporary work visas, people who are applying for business-related visas, or people who are changing from one type of non-immigrant visa status to another, also have to attest that they haven't received any of those benefits, which is a largely academic issue because they're not eligible for those benefits, so they wouldn't be able to get them in the first place. But it's an example of how far-reaching the new public charge rule definition is.
Right. So, I mean, so how I see it is, before the public charge rule, it was really based on evidence and the facts. If somebody became a public charge, then it was evident based on what he or she received. Now it's kind of seeing into the future. It's very subjective. It's discretion of the part of the visa officer or the immigration officer. So if you have somebody that doesn't like you for whatever reason, could they make that determination?
Well, it's not that entirely that arbitrary. And of course, because it's so new, so it only applies to applications that were filed on or after February 23rd of 2020. So none of those applications have yet reached the point of adjudication. So we don't know how individual immigration examiners or officers are applying it. But in practical terms, what difference this makes to people who are applying for green cards for permanent residence is that you have to file a form called an I-944. Or if you're applying for an immigrant visa to a consulate overseas, you file a form, it's a DS-5540. And the I-944 is a statement of the applicants and the sponsoring family members' financial status, assets, list of any benefits that have been received at any point in the past, property that they own, copies of tax transcripts, a credit report if one is available. If one is not available, an explanation for why there is no credit report. If the person has a poor credit, as distinct from no credit history, then an explanation for why they have a poor credit history, a statement of their English proficiency, and numerous other details like that. And then when the immigration officer is reviewing the case, some of those factors are considered heavily weighted negative factors. The biggest heavily weighted negative factor is going to be receipt of public benefits in an aggregate of 12 months. And so what I mean when I say in an aggregate, the new immigration rule on public charge and this form, they list a number of means tested public benefits. And to have received more than 12 months of those, it doesn't mean that you are required to have received one specific benefit for a period of 12 months uninterrupted. It means if you have received any benefits at any point, the time during which you received those benefits, even if you got two of this at the same time, will count towards that 12-month period. So it's 12 months, all benefits received in the aggregate. And so it's quite easy without you know, because sometimes I think people are going to think, well, I got that for 10 months, and so it's not 12 months, so it's fine, but it's not. It is, you add up all of the benefits you've ever received and see if that totals a period of 12 months. And that will be a heavily weighted negative factor. On the other hand, a heavily weighted positive factor that my understanding is that immigration officers should really not go behind if you show that, is if you have your household income is more than 250% of the federal poverty guidelines. And of course, 250% is a very big number, but on the other hand, the federal poverty guidelines are actually pretty low. So what constitutes the poverty level here is pretty low. So if you have a household of two and you have a household income of over $45,000, then you're making over 250% of the poverty guidelines for a family of two. So that would be a heavily weighted positive factor, which would outweigh a receipt of public benefits. And then other factors that they are required to take into account is the person's age. Obviously, if you're very elderly, that would be more of a negative factor in terms of public benefits rather than if you're 25. Your health, and of course you have to submit a medical report from a doctor with your green card application. So you have to be honest about what your health situation is. If you have health insurance, if you're eligible for health insurance, your English proficiency, your job skills, your education and employment history, all of those things are factors that they consider. And so it's not a complete, I mean, the ultimate decision is discretionary with the immigration officers, but they need to take those factors into account.
Right, that's the totality of circumstances.
Yes. Yeah.
Now, I'm sure you're getting calls, we're certainly getting calls, you know, every day about various relief amounts that are available to, you know, due to COVID-19, such as the PPP, such as the disaster loan, such as unemployment benefits. And people are worried if that's going to be causing them having public charge issues in the future. What's your take on that?
So the public charge rule went into effect before we were faced with this crisis. So, and before coronavirus became a problem. So it doesn't directly address it, but USCIS has issued guidance saying that any benefits received by intending immigrants or by people who have already gotten green cards as a result of COVID-19 pandemic, like because of the shutdown or because of health related, they need treatment, they need testing because of coronavirus, that will not count as a means tested public benefit for purposes of public charge rule. So people
only
should,
COVID, but only COVID related. So if you have to go to the emergency room because you're coughing, that's not going to cause problems for you immigration wise within public charge realm.
Right. And also there are, even apart from COVID, certain types of emergency medical benefits do not count towards the public charge rule.
Okay.
So
as you said earlier, asylees and people who have withholding and so forth, they're not subject to it anyway.
That's correct. And I think you can, I mean, generalizations are kind of bad in law and in immigration law in particular, but I'm going to make one anyway. And that is that the public charge rule doesn't apply to, in general, it doesn't apply to people who have humanitarian based benefits. So so asylum is considered a humanitarian based thing. Benefits under the Violence Against Women's Act, people who are victims of trafficking, people who are crime victims, or people who are granted cancellation of removal by an immigration judge in immigration proceeding in immigration court. None of those are subject to the public charge ground of inadmissibility. People should also be aware that there is, while there isn't a waiver directly of the public charge ground of inadmissibility, if you're subject to it, you're subject to it, and then you just need to prove to the immigration officer that you can overcome it. But there is a provision to post a bond, a public charge bond. And the amount of the bond is discretionary with the immigration officer, depending on the basis on which the reasons that they've determined that you are inadmissible as a public charge. But it, at a minimum, has to be $8,100, and that is revised upwards every year based on cost of living increases. Um,
is that when you're in immigration court or even outside?
Even outside. So let's say you go to your green card interview and the immigration officer reviews all your financial information and benefits and then says, okay, well, I've reviewed this. I've determined that you're inadmissible as a public charge, and that you can overcome this ground of inadmissibility if you file a bond of $8,500 with USCIS. And then you file that bond and then you can proceed to get your green card.
Good to know. I just want to add, and we've talked about this before, as far as unemployment insurance in California and in most in most states, there's two periods, the base period and the benefit periods. For somebody, even on a non-immigrant visa, to be able to draw unemployment insurance money, they have to have had status during the base period when they contributed to the program, and also during the benefit period when they're trying to draw. And that's going to be tricky and almost impossible for a non-immigrant person on a visa. But if you're a green card holder, you're good to go, as long as you had the green card prior to and green card after when you're trying to draw. Am I correct?
Yes, absolutely. One other related issue is that's been in the news a little bit. And first of all, I want to say that the reason that the public charge issue has been in the rules so much is because the rule was proposed by Immigrate by the president and the administration last year. It was a huge departure from what the public charge rule had been previously, and it was extremely controversial and it got a lot of media attention. And then there were several court cases which challenged it, and even though some of them are ongoing, the rule itself has been allowed to go into effect. And that's why it's been in the news so much. And as we talked about, it just went into effect on February 20 for applications that are postmarked after February 23rd of 2020. So if people have green card applications that were filed prior to then this rule does not apply to them. There was another related and in my opinion, redundant rule issued by the president as a proclamation last year, saying that people who are applying for immigrant visas at US consulates overseas need to be able to prove that they will be eligible that they will have health insurance within 30 days of arriving in the US, or that they have enough money to cover their own medical treatment. I think that few people, and that rule has been enjoined, as in the courts have prevented that rule, at least for the moment, from going into effect. But again, it's been in the news. It may go into effect in the future. Again, it seems unnecessary, given that the new public charge rule says that lack of access to medical insurance and age and health circumstances is a factor that immigration officers have to take into account. So it's already there as an issue that most immigration officers, or consular officers rather, are going to be addressing. And then in terms of the health insurance aspect of it, I think most people are not going to be able to show that they have enough money to pay for their own medical treatment, given how incredibly expensive it is to pay for your own medical treatment. And proving that you can get health insurance in the US within 30 days of arriving here is also going to be very difficult, because you can't get health insurance in the US unless you're in the US, and unless you have legal status here, and usually unless you have a social security number. So people will not be able to get health insurance before they come here. And then in terms of if this rule does go into effect, how would you prove that? Well, I think the way to do it would be, number one, to show what your anticipated income and assets will be, and then get a list of health insurance programs that would be available to you and that would be affordable. Or if you're being sponsored by a family member and they have a family-based insurance plan that the person could be covered under, then proof of that. Or if it's an employment-based immigration application, then proof that the job offer also includes an offer of health insurance.
Right. Also, there's high-risk policies that as long as you're on US soil, even if you don't have a social security number or legal status, as long as you're on US soil, they'll charge you arm and a leg, but they'll give you a policy. So that's also an option. It's extremely expensive.
Right. Which then might also become somewhat of a negative factor in the overall totality of the circumstances if your health insurance was so expensive.
Right.
That it could factor into other things.
Right. Fascinating conversation, Paul. Thank you so much for giving us your time. I hope that you'll agree to give us even more time as we come up with other topics.
Always happy to. Maybe we'll have a cheerful one next time.
Okay.